My name is Alan Haley. Welcome to tonight's episode of Tenant Thursdays. I am the Director of Development and Communications for Lawyers Committee for Better Housing, or LCBH. We are a 40-year-old organization that serves renters citywide and parts of Cook County, providing representation, legal services, and supportive services for renters facing unjust evictions and living in substandard housing. Tonight's episode of Tenant Thursdays will focus on the topic of understanding lease agreements. And I'm delighted tonight to welcome my colleague, Carl Sessions. Carl is one of LCBH's attorneys and will be leading the discussion tonight. If you have questions, you can put them in the chat, and I will pose those to Carl after his presentation. But to get things started, Carl, if you would please introduce yourself and let our friends know what it is that you do at LCBH.
Hey, good evening, everybody. Thanks, Alan. It's great to be here. I am a staff attorney and I represent tenants in eviction court at LCBH. And I'm happy to talk about rental agreements tonight because pretty much everybody has them. If you live in Cook County in an apartment, then you do have a rental agreement, whether it's written or verbal. So it's an important topic.
Well, thank you, Carl. I know you've created a wonderful PowerPoint presentation tonight that you'll share with our guests.
Yep. Let's see here. Okay, so let's get into it. Understanding rental agreements is what we're going to be talking about. So first off, just a vocabulary term. When I talk about the Chicago Residential Landlord Tenant Ordinance, aka the RLTO, that is a source of a lot of protection for tenants in Chicago, but it only applies to some tenancies. It basically applies to every tenancy unless you live in a building with less than 5 units and that's landlord occupied. So when I talk about RLTO, you can assume that you're covered if you live in Chicago, unless you live in a small building that your landlord also lives in. So let's talk about what a lease must include. And by the way, when I talk about a lease or rental agreement, it can be written or it can be verbal. And a verbal rental agreement can exist whenever you're paying rent in exchange for being able to stay in a place. It can be super informal. So a lease must include the name and address and phone number of the person who owns it, as well as an identification of who you can send notices to. So if you're having any problems at the unit, they must tell you who can receive legal notice. The lease also has to include if there's been any code violations. So for instance, if there's like inadequate heat and the city, got them in trouble, then they have to disclose that violation if it happened within 1 year of the rental agreement being formed. So when you start a new tenancy, the landlord also has to give you a summary of the residential landlord tenant ordinance and a bed bug pamphlet giving information about bed bugs. Chicago has one of the worst bed bug problems in the nation. And the landlord also must give you a lead paint disclosure about if there's lead paint at the property, as well as a disclosure of what the heating costs are, the utility costs. A landlord's failure to do any of these could be grounds to terminate your lease. I recommend looking at the RLTO online for more information, but if you're in a bad situation and you want to cancel your lease, we'll talk about that later, but you can look at these entitlements. I mean, these are things you're entitled to. If the landlord fails to provide them, you can provide notice, and if they fail to correct the issue, you may be able to terminate your lease without any penalty. So that's what they have to include. There's also things that they cannot include in the lease. So this is again for the RLTO buildings only. So the landlord cannot require you to waive any rights that you're guaranteed, such as to a jury trial or to any rights under the RLTO. They also cannot require you to pay for attorney's fees if they sue you for an eviction. Outside of Chicago, they may be able to do this, but if you're an RLTO building, you will never have to pay your attorney's fees, your landlord's attorney's fees if they end up evicting you. And if you're ever in a situation where you've received a notice, an eviction notice, it's a serious situation, we may be able to help. We recommend that you contact us. The lease can also not require you to pay excessive late fees. So the last point down here kind of talks about what is an acceptable late fee. So an acceptable late fee is $10 for the first $500 in rent. So if you're renting a place for $500 and you pay late, your landlord cannot charge you more than $10. If they do, there's penalties. And then if your rent is more than $500, the maximum late fee is 5% of the amount that's over $500. So if you had $1,000 in rent, they could only have a late fee of $35. Okay. So security deposits, there's a lot of security deposits. The landlords have to follow very strict procedures. So the idea of a security deposit is that the landlord has some kind of security. If you damage the property, they can use the deposit to pay for the damage. Makes sense, but landlords oftentimes will mess up on the procedures for doing this. So the RLTO and state law, so if you're not an RLTO building, you're still protected by this, requires that they have to pay you interest on the security deposit. They also have to keep the security deposit in a separate financial institution than the landlord's own property. So they can't commingle your deposit with general operating expenses of the business. Once you move out, they have to return your security deposit. If they want to keep any part of the deposit, they have to send you within 30 days a itemized list, a specific list about what the problem was. That includes a receipt or an estimated cost of repair. And then they have to give you any remaining funds that's left over. One thing that happens is landlords will not call something a security deposit, but they'll say, oh, it's just a move-in fee. And they do that to kind of get around these strict requirements. For the most part, landlords are able to do a move-in fee instead of a security deposit, as long as it's not like 2 months rent. If it's like 2 months rent, if it really looks like it's a security deposit, excuse me, I got my second COVID shot yesterday, so I'm feeling a little under the weather. So if it looks like a security deposit, they call it a move-in fee. There's some case law, some appellate case law that says the courts are going to treat it like a security deposit because they're deliberately misnaming it. For the most part, if it's a move-in fee, it's just a move-in fee. So a common question that we get is questions about rent increases and termination notices, no-fault termination notices. So the RLTO does address both of these situations. As far as rent increases, unfortunately, landlords are able to increase your rent as much as they want because we do not have a rent control in Illinois. Talk to your local politician if you want to help change that. But as far as notice, you are entitled to notice before they can increase your rent. And so this slide talks about that. So if you've lived in your property for less than 3 years, they have to give you 60 days notice at least before they can raise your rent. And by the way, they can never raise your rent in the middle of your lease. If you have a 1-year lease for $1,200 a month, 6 months into your lease, they can't raise it. This would be, they have to give you a new lease after the expiration of your lease, and they have to give you 60 days notice before the end of your lease that they're going to increase your rent for the new lease, if that makes sense. If you've lived there for more than 3 years, they have to give you 120 days notice. And these time periods apply for both rent increases and also termination notice is. So if I've been at a place for like 5 years and the landlord wants to not keep me as a tenant, they have to give me at least 120 days notice of saying, I'm not going to renew your rental agreement. Another thing is that leases cannot require tenants to do maintenance or repair obligations. So the RLTO provides at section 512.110 a list of responsibilities for landlords, and the landlords have a long list of responsibilities that they're not able to delegate to tenants in the lease. You can look at that site for a full list of the tenants or the landlord's responsibilities. And so last slide is about the Cook County Ordinance. This is very similar to the Chicago Ordinance that we were talking about. And so if you live in Cook County and you're not covered by the RLTO, you will be covered by the Cook County Ordinance, which goes into effect on June 1st. And it's going to provide many of the same requirements as the RLTO as far as the lease. So they have to give, at the time that the landlord enters a rental agreement with you, they have to give you a summary of the ordinance. They have to disclose the owner, the manager, they have to disclose lead, they have to disclose heating costs. And they also cannot make you waive any of your rights that the ordinance gives you. So Alan, that was what I had. And I think you're on mute.
Sorry about that. Thank you, Carl. There were just a couple questions. What if a tenant needs to terminate his or her lease early? What happens?
So it's a very common situation. There's a lot of reasons why somebody would need to get out of their lease early. It is a case-by-case basis. I'm not going to give specific advice right now. Generally, you want to look at your lease to see what it says about this specific situation. A lot of times the lease will have a buyout clause or a buyout provision, which says, something like if you pay 2 months rent, then you could cancel the lease and you won't be responsible. Generally speaking, if you've signed something, then you're going to be responsible for paying rent, even if you give advance notice. But what's recommended is that if you do have to leave and if you don't have a buyout provision or you don't want to pay the buyout provision, then give as much notice as you can, pay rent for as long as you can, and then try to get an agreement with the landlord where they let you out of the lease. Worst case scenario, the landlord does have a duty to mitigate, which basically means they have a duty to try to find somebody to take your spot as soon as possible. So once you've given notice that you're going to sadly have to break your lease, they can't just sit on it for another 6 months while it's vacant and charge you rent. They actually have a duty to try to find a new person. But until they find a new person, you will be responsible.
And how does the rental renewal process work if you decided you don't want to continue your lease? What are the procedures for that?
Sorry, what was the question?
How does the rental renewal process work? If your lease is about to end, and how does the renewal process work?
So I think, it depends on a case-by-case basis, but if you want to be on a written lease, there's advantages to that. So you could ask your landlord for another written lease for a certain period of time. If you don't sign a new lease, that's fine. Like I said earlier, there's still there's still a formal legal relationship if there's no contract, if there's no lease. Just by the very fact of you staying in the apartment with the landlord's permission and paying rent, that's going to establish a tenancy in an unwritten rental agreement. So if you used to have a lease, it expired, then you kept staying there and you kept paying rent, what's going to happen is that a month-to-month tenancy is going to be created. So you're not going to be entitled to stay there for a year. If they wanted to, they could give you a notice of 60 days or 120 days saying you have to leave, but you don't need to sign a new lease. So it's kind of up to you about if your lease is coming to an end at your current place. If you want to ask for a new lease, you're going to be locked in, but it's going to give you more protections as far as your landlord just can't kick you out real quick.
Okay. And are landlords allowed to require someone to have renter's insurance?
That's a great question. Landlords can require you to have renter's insurance, but if they don't require you to have it, you don't need to have it. It's kind of a personal decision. I've definitely seen situations where tenants do not have renter's insurance and property was destroyed, for example, through a fire, and they didn't have any recourse. And so that's really sad when something like that happens. On the other hand, paying a premium every month, even if it's only $10, might be hard. So overall, landlords can require it, and a lot of times they do require it, but it could be a good idea.
Well, Carl, this has been very informative. Are there any closing comments that you want to share in terms of just renters being aware and cognizant of what's in a lease and making smart decisions for themselves when they enter into one?
I would say up top that sadly we are in a lot of people find themselves in a situation where you can't really negotiate with your landlord about the terms of a lease. Most of the time when you're on the market looking for a place, you kind of have to accept whatever lease is offered to you. So given this situation, it still makes sense to understand what you're agreeing to. So my final recommendation would be just to really read the lease before you sign it. And if you find anything that's obviously problematic, to just talk to your landlord about it. The other thing I encourage you to do is to read the RLTO. It's available online. If you are having difficulty understanding your rights, please reach out to LCBH or other legal aid organizations, or drop a question in the chat, and we'll do our best. But I know that coronavirus has made it very difficult for a lot of people, and just being proactive generally and knowing that you do have rights, even if you don't understand them, they are there, and there are people out there who want to help you out. So reach out to help if you need it.
Well, thank you, Carl, for being part of Tenant Thursdays tonight and for all you do for LCBH and Chicago renters.
Thank you, Alan. It was good to be here. Appreciate it.
All right. Thank you. Have a good night, everyone. And we'll watch for updates on next week's topic. Good night, everyone. Good night, Carl.
See ya. Good night.